Good morning. This is proceeding for the National Child Protection Alliance versus the Commonwealth of Australia. The date is Monday 12th of September 2016 and the time is 10 a.m. Australian Eastern Standard Time. Presiding over the matter is Sir John Walsher-Brenner, Chief Justice of the ITNJ. We also have Julianne Foe, myself, and Shay Woodward, Court Officers of the ITNJ. The applicant in this matter is the National Child Protection Alliance, which will from now on be referred to as the NCPA. Is there a representative present for the applicant today? It seems we have no one present for the applicant. We will continue with the proceedings regardless, so that some issues can be clarified and put on record. The respondent in this matter is the Commonwealth of Australia. Is there a representative for the respondent present today? It seems we have no one present for the respondent. We will continue on with the proceedings so that we can have some issues clarified and put on record.
The purpose of this hearing is to determine where each party currently stands, provide the public and tribunal with an update of the current status of the action and future proceedings, if any will be taken by the NCPA. Today, we will provide a brief summary of the case, the events in the lead up to the trial, and seek further clarification on some issues which have been raised in the ITNJ proceedings to suggest to put them on hold. We will then give both parties the opportunity to comment. In light of the recent circumstances, we will then seek confirmation from the applicant about whether they request the proceedings to be permanently withdrawn or temporarily put on hold. If this clarification cannot be achieved today, the proceedings could be adjourned to a date or to another date or sine die, or could be struck out. We also note that pursuant to the Constitution of the International Tribunal for Natural Justice 2015, these proceedings are being recorded, as no formal objection has been raised by either parties. It is being recorded by ITNJ technicians and will be published along with the transcript on the ITNJ website. However, they are not being broadcasted live for security reasons. If anyone has any objections to this procedure, please make that known now before we proceed.
It appears there is no objection. The ITNJ received an application from the NCPA, the National Council, the National Child Protection Alliance, in December last year, December 2015, which was later accepted. The application was for a declaration to be made that the Australian Family Law Act and its implementation by way of the family courts, the judiciary, the legal system and law enforcement are in direct breach of the United Nations Convention on the Rights of the Child, Articles 9 and 24 specifically. And the declaration was to recommend changes towards justice and fairness and recognition of the rights of children in Australia, whilst addressing the issue of domestic violence, including child protection. After that was received, a directions hearing was held on the 12th of February this year. Two representatives from the NCPA were in attendance, and I'll refer to what happened at that directions hearing. The two people who attended the directions hearing, including who was the head of the NCPA, and we went through the procedure of the ITNJ rules, and we discussed a number of procedural matters. In relation to the evidence, it was discussed that witnesses could be present and give viva voce evidence in person, or depositions could be taken, or they could give evidence by way of video link. The NCPA was of the view that maximum impact would be gained by having people present who were willing to give evidence. One of the witnesses was one of the children who had been abused, who is now over the age of 18. The relevance of that is that under the Family Law Act, people who take part in proceedings are prohibited from discussing the proceedings afterwards, and that prohibition extends to going to the police to complain about violence or sexual attacks on the children or anything else. That binds any child who is part of a custody battle under the age of 18 from even complaining about the matter. We discussed very thoroughly during the directions hearing the way the hearing would take place. At that stage, the Commonwealth of Australia, as the respondent, had indicated to the tribunal they would not be attending, but as a courtesy, we, as a tribunal, sent them copies of the directions hearing, and we also made it a requirement on the applicant that any documents that they served also be served on the Commonwealth. I could add there that the Commonwealth indicated they didn't necessarily accept the jurisdiction of the International Tribunal for Natural Justice, in the same way they don't accept the jurisdiction of the Permanent Court of Arbitration and various other international bodies. I think the difficulty that the NCPA sees in the Commonwealth's stance is the Commonwealth, as the Commonwealth of Australia, ratified the Convention on the Rights of the Child, and then the applicant is of the view that it has been largely ignored. After the directions hearing, there was discussion with the NCPA and arrangements were made for a hearing. They wanted some time to get or clarify the witnesses who would actually be giving personal evidence, and they wanted matters of security and anonymity to be covered. That was done, and ultimately in July and August dates were discussed. The ITNJ indicated it would cooperate by having hearings during a week that was suitable to the applicant and to the witnesses, and eventually the date of the 12th of September today was set down. Then in the last couple of weeks, the applicant has expressed to the tribunal a number of concerns which really hadn't been raised before, but these included real threats to the security of witnesses and its own members. In fact, there is minutes of the meeting of the NCPA National Executive Council on the 24th of August. The tribunal received a telephone call from and he indicated that they had had an emergency meeting and they were requesting that the hearing not go ahead on the 12th. This was on the Wednesday the 24th of August. At the same time, he indicated he wanted to have a meeting on the 5th of September. Subsequently, we wrote to the NCPA and indicated that if any party wanted to have a meeting with the tribunal, and specifically with the judge hearing the case. That could only take place if the respondent was advised and the respondent was given an opportunity to attend. The minutes of the emergency meeting of the NCPA National Executive Council held on the 24th of September this year, a statement was issued by them, and I'll read it out. It says, "We have received information that some militant fathers' rights supporters and other civil rights groups may be planning to disrupt the ITNJ proceedings and use such proceedings to promote their own causes. We are already severely constrained in presenting our case before the ITNJ by the legal requirements of Section 121 of the Family Law Act and have taken every possible step and exercise due diligence to ensure that the identities of those participating and who are still engaged in family law proceedings would be secure and protected. Several of the witnesses are suffering complex post-traumatic stress after suffering years of abuse and violence in domestic matters and from subsequent legal abuse, and are extremely emotionally fragile and will require support and reassurance throughout the proceedings. Some potential witnesses have already withdrawn as they could not face the stress of appearing in the proceedings. If such disruptions and misuse of the proceedings were to occur, then those appearing would undoubtedly be exposed to further stress and anxieties and possible exposure of their identities. It is our duty and first priority to ensure that those vulnerable parents and children are safe and protected." Then it goes on to say, over several years and in recent weeks, officers of the NCPA have received a great deal of harassment, abuse and threats of harm and death from militant fathers' rights supporters, but have always been prepared to continue their work despite such occurrences. There is therefore a risk they may also be exposed to risks of harm during the course of the hearings. In such circumstances, it's been decided by the NCPA Executive Council to postpone the proceedings with the ITNJ sine die until such matters can be fully considered and an alternative strategy be devised in order to bring to public attention the harms which are being caused to children and young people by the Family Courts of Australia. We shall be considering these matters very carefully over the next few weeks and determining how and when we will proceed in these matters with minimal risk to all participants. That was on the 24th of August. We responded to them and pointed out that in the directions hearing that took place in December, we made it clear that arrangements were being made, firstly to take evidence by way of deposition or affidavit, and secondly that anyone who did not wish to have his or her identity known, steps would be taken to mask the identity either by a screen or by some other method of the evidence being able to be given without the physical identity of the person being known or any information being given leading to the identity or address of the person. Now, the booking for the hearing, it was to take place at Monash University Law Chambers, in fact just around the corner from this office, and the booking was made direct by the NCPA, and the booking was signed by who sent that minute that I had just read out, and the date of the booking was the 17th of July. So 5 weeks elapsed before the NCPA decided that they didn't want to proceed. Their position is a little unclear at the present time because we're not quite sure exactly what it is. We asked whether they wanted a postponement, and could it be to a specific date? And some of the answers we've been getting have been a little confusing. Where's the rest of my... yeah. Good, thanks, Carl. Now, if the application is to be indefinitely withdrawn, the tribunal has an obligation to make a decision as to whether the matter is to be adjourned to a fixed date or to an uncertain date, and also, apart from the people in this room, there are a number of other people that are involved in getting ready for any sort of court hearing. Costs have been incurred, and I'm quite sure that the Commonwealth isn't going to object to the NCPA pulling out at this stage. A decision has to be made as to exactly what the NCPA wishes to do. If it's to be temporarily put on hold, we need to set down a date for the trial and then address the security and privacy issues, ensuring the safety of all involved for further hearings. I can repeat that we covered this matter during the directions hearing, and in the correspondence that we've had since the NCPA indicated that they wanted to, as they put it, put matters on hold, we've certainly clarified that there is no need for people to put themselves at risk in giving evidence. It was the NCPA that wanted to have people give live evidence, and one of the main witnesses they were going to call was one of the victims, who was now over the age of 18, who wanted to let the court know and the world know what happened to her. The statements that were given to us indicated that a lot of the harm that had been done could have been stopped at the family court level or at the police level, and had not been. We're trying to clarify what the NCPA position is. If they were present, I would ask them, and we haven't heard anything for the last few days. We've been trying to find out from them exactly what they want to do, and I think it's our obligation to make a decision. And what I propose doing is to indicate that unless we get a firm decision from the NCPA and a firm date set for the trial by a certain date, that the matter be struck out. What struck out means is that the matter will be removed from the list, and the NCPA will no longer be an applicant, and if they want to reinstate the matter, they'd have to basically start afresh. It's different from a dismissal. Dismissal is only when the evidence is heard, both sides are heard, and a decision is made. So we're not saying that their application's dismissed. What I'm saying is that I will set a date by which time we want the NCPA to be firm in its resolve to go ahead, and if we don't hear from them by that date, I propose that we do that, the date be 1 month from today, that if the NCPA wishes to proceed within 1 month from today, they are to let us know that they are going to proceed, they agree on a date for the trial, that costs are paid. I should indicate in relation to costs, we had the directions hearing back in February. There was, although there's always a court fee cost, we didn't charge a cost at that time. But I think in relation to what some might see as a waste of time today and a waste of time this week, because quite a number of people arrange their affairs to be in Melbourne for the week, to be present during it, and I think it's only fair to say that that the NCPA should be ordered to pay some costs, and what I propose is that the NCPA be ordered to pay the cost of one day's hearing, that is today, and the court scale is because we operate as a London-based tribunal operating internationally. The fees are set in British pounds, and the fee for a day's hearing is £2,000. So I ordered that the NCPA pay the sum of £2,000 for forcing us into a position where we're unable to proceed today.
Given that Chief Justice Sir John Walsher-Branner has decided that the NCPA has until 1 month from today to formally declare that they will be proceeding with the matter, so that being 12th of October 2016. If the NCPA is unable to do so, Sir John Walsher-Branner will be striking out the proceedings and costs will be ordered against the applicant. The order will then be forwarded and sent out by email to both parties within 7 working days of that date.
Yeah, perhaps I should clarify on costs. The NCPA are ordered to pay costs now for today's proceedings of £2,000. If we hear from them within a month, another date will be set. The hearing will be set down for, it was estimated it would take 5 days, so it would be set down at a suitable date where we could have continuity of five straight days. It's always, particularly in sensitive matters, it's always helpful if a case lasts more than 1 day to have them in continuous days rather than having it split up in hearing 1 day 1 week and 1 day another week and so on. If the NCPA do not let us know that they are prepared to seriously go ahead within that 1 month, then the matter will be struck out and the NCPA matter will not be before the ITNJ. That's not to say that the issues that they raise of protection of children and abuse in custodial matters can't be addressed by somebody else. It's significant that while these proceedings were being listed, there is a Royal Commission in Australia in relation to institutional abuse of children, and the ITNJ application is not against a specific church or orphanage or school or whatever. It's actually against the system that over the years has evolved, where for some reason in a custodial battle the real interests of the children are not being heard, and children generally are not allowed to give evidence and their views are largely disregarded, and it appears from the material put before the tribunal that there has been a policy decision in relation to the administration of family law matters that both parents should be given equal rights and equal custody of children, irrespective of any problems with either parent, either father or mother. I noticed that the NCPA talks about fathers' rights groups and threats of death and harm to them. I know on the telephone actually also mentioned, apart from death threats, having his house burned down. What I would like, have you got that thing from Sasha? The message from Sasha? Did you bring it in? Can you just hold on? Sasha sent a message this morning.
Oh, this morning?
Yes. I'll just see if we got it here in this bundle of papers. No. Look, I was just going to say, just as that although there's been talk of death threats and harm to witnesses and harm to the people running the NCPA, no one seemed to be concerned about the court staff, and Sasha Stone sent an email this morning thanking both Shay and Julianne for lasting the distance, and we're not being frightened away, we will be here to hear the case if the NCPA do come back to us, and the ITNJ will be here to hear any cases that come before it. So I think that might be a closing signal.
Is there anything else you want to cover?
No.
So that appears to conclude today's hearing. A transcript of the proceedings will be sent to both parties and published on the website. The video recordings will also be made available as soon as possible and accessible via the ITNJ official court website. A copy of the orders made today and the quantum of costs will, as John said, £2,000 will be sent out to the parties in due course. And that concludes today's hearing.
The matter is now stood down.